Hey guys, welcome back to today's video. We've got a wild one lined up, a sovereign citizen who's chosen to represent himself in court. And it's honestly the kind of case that would fill up an entire sovereign citizen bingo card in no time. Seriously, I'd challenge anyone watching to keep track of just how many classic arguments he throws out as this unfolds. It's a long video packed with moments you won't want to miss, so sit back and let's dive right in.
So the motions that were filed by Mr. Chavez are they're not all labeled motions, but the filings that were filed were a verified affidavit, verified motion to dismiss with prejudice, a notice of special appearance, an affidavit, a fee waiver demand, an affidavit of indigency. There was a lawful demand for continuance, an affidavit of good cause, an exhibit list, motion to admit exhibits into evidence, and a certificate of service. There was also a general memorandum of law that was filed.
Yes, and I see that. I guess all of those were filed on August 14th. Obviously 12 days ago. I guess I would just ask the defense to clarify what they're wanting to litigate here today, specifically.
Sure. I think that would help us determine how to proceed. There was also a supplemental affidavit of a constitutional violation, essentially challenging stop, which I think could be interpreted as a motion to suppress. Okay. All right. So several motions have been filed. Again, we do need to determine how to proceed today. Mr. Chavez, I did also see a motion to continue in these filings, but the way I interpreted that motion to continue was that you were requesting that the court accept your motions because they were filed outside the 14-day deadline.
It was, no, if I may.
Yes, you may.
It was to cure. I'm in the process of moving and a lot of personal things. I was trying to meet your the required timeline that you gave me, in good faith. That was why I requested that. And again, that was more or less the reason why I requested a continuance, just to make sure that everything was filed. You had enough time to view the material. All right.
Well, I think I interpreted it correctly then.
I would.
The motions were obviously accepted by the court. Usually the remedy if a party files motions late, especially when we're in the pre-trial process, a trial has not been scheduled in this matter yet. So from a procedural standpoint, the remedy would be if for some reason, if the prosecution needed more time to respond to those motions, the remedy would be continuing the motions hearing to allow more time for a response from the other side. So that's really with respect to the late filing of the motions are certainly accepted. But that's why I asked today whether the prosecution was prepared to go forward to address those motions today.
I think if we can, so my understanding, I guess, at the moment is this is essentially a reasonable suspicion, suppression, probable cause suppression, and then a jurisdictional motions hearing?
I believe so.
The jurisdiction needs to be established before proceeding any further. That's foundation of law.
Look around you where you're sitting right now already establishes personal jurisdiction. As for subject matter jurisdiction, that will be confirmed once the officer testifies about when and where the traffic stop took place.
For the record, I appear, especially, not generally. My presence is under duress, coercion, and threat of arrest if I fail to appear. This is not a voluntary submission to jurisdiction. I reserve all rights. I make no waivers. And I demand the court prove jurisdiction on the record before proceeding any further. You came in here and said the court is the people versus Ryan Chavez. The state and the people are a fictional entity. They cannot be cross-examined. They cannot testify. They cannot take an oath. So I demand that a living man or woman take the stand and that an injured party is presented. Otherwise, this case needs to be dismissed with prejudice.
Do the people intend to call a witness this morning?
I was going to call the officer who pulled him over on the day of the offense.
Is the officer the injured party?
An injured party is not required, Mr. Chavez.
It absolutely is required under Terry versus Ohio and Delaware versus Prowse. It requires articulable suspicion of a crime. Muddy plate is not probable cause, and obstruction further needs to meet Colorado Revised Statute 18.1041A, requires physical interference, and Courier's own affidavit admits no act of obstruction ever occurred.
Your argument is noted. It's rejected by the court.
It's not an argument.
I'm denying that argument.
Of statutory.
You're making a record right now, and I'm denying any assertion that you're making that an injured party, a specific injured party, is required in this case. This is a statutory violation. The legislature of the state of Colorado has
constitutional protections and rights.
Okay, your record has been made.
It's a statutory fact under Colorado's own statutory law, and I will provide that to you. 3812-1409. Colorado codifies federal law shall govern and supersede conflicting state provisions. Colorado statutes do not supersede or override constitutional rights, protections, or federal law.
Okay.
So
how does that impact these?
So
these
for the
proceedings?
record and on the record, you are denying the supremacy clause.
What federal law are you invoking here?
The supremacy clause. You are bound to stand within the supremacy
What
clause.
I'm asking you, Mr. Chavez, how does that impact these proceedings?
Well, until you prove jurisdiction, present an injured party, this case needs to be dismissed with prejudice.
That's what we're here to do today.
Well, you still need to prove jurisdiction before we proceed any further.
You're exercising your right to due process right now by by filing motions and invoking a hearing on those motions. And that's what we're carrying out today. I will hear testimony and argument from the prosecution as well as you, and I will make a ruling on jurisdiction and on the veracity of the stop, whether there was reasonable suspicion of probable cause. Okay, you are exercising your due process right now, whether it's state due process, federal due process. That is the proceeding we're carrying out now.
Correct.
Okay, so none of your rights are being violated.
Not yet. They have already been violated by Courier's stop.
Well, that's what we're here. That's what we're here today to determine. Okay, you need to let these proceedings go forward.
Well, you need to prove jurisdiction before we can proceed any further. You can't just jump and go to one thing to the next thing.
This court has jurisdiction over this proceeding.
And what proof are you going to provide me with?
We're going to hear testimony so I can determine whether or not I have personal jurisdiction over you based on the officer's testimony.
That's not how it works.
Yes, it is.
No, it's not.
Okay, we're going to go forward with these proceedings. If you want to appeal after we're done with these proceedings, you are welcome to. Okay.
Well, I reserve my rights under Title 42, 1983.
They are reserved.
1883, or excuse me, Title 18, 241, 242. Because at this point, you are in direct violation of my rights without proving jurisdiction.
What statute is that?
I just provided them to you. Those are United States codes, which again are
You're citing federal codes.
It doesn't, they supersede state, and you know that.
What he understands, at least in part, is that federal laws generally apply to federal cases, and under the 10th Amendment, states retain the authority to govern themselves. That's why state laws apply to state-level matters like his case. Now, to set the stage, I'm going to play a brief excerpt from the prosecution's questioning of the officer who conducted the traffic stop, and then we'll jump straight into his cross-examination, which, frankly, is something else entirely.
And did you speak with Officer Jennifer Cruzy of Blue River Police Department about Mr. Chavez?
I did.
And what did she have to say about him?
Well, when I was back in my vehicle reviewing his history in Summit County for traffic stops, I found that he had been stopped twice prior, in approximately the last year by Officer Cruzy. One time was for speeding, the other time was for obstructed license plate and I believe registration. She told me that he was uncooperative with her as well, refused to provide driver's license, registration, insurance. She ultimately ended up letting him go with warnings both times. She told me that she was, after a lot of talking with him, able to convince him to provide her with she called it a sovereign citizen ID. I don't know what that is necessarily, but she said he provided that.
Okay. What's the objection?
That's prejudicial. You cannot use that term. I demand it be stricken.
What term?
Sovereign citizen.
We are not in front of a jury.
It's defamation.
There's no
Without
prejudice.
Proof you cannot use it against me. I'm not a domestic terrorist.
I'm not striking that. Your objection's overruled.
Okay,
There's nothing.
Show that this court is refusing to abide by federal law. It is condemned by federal law.
Yeah, you may begin your cross-examination.
I invoke the hostile witness.
Excuse me?
I invoke hostile witness. They need to ask her leading questions.
You're allowed to ask your leading questions on cross.
Would you consider yourself an expert?
Yes, I've been sworn in as an expert in traffic.
Okay, and in your own affidavit, you admitted, and even to me, that during the stop that you don't know every Colorado revised statute. Is that correct?
Yes.
Okay, so it's safe to say that you're not an expert.
Depends on your definition of an expert.
Well, you just said you were an expert, but you just also in your sworn affidavit said you don't know every Colorado statute.
Correct. I don't need to know every single statute, but if your definition of an expert is to know every statute, then no, I would not be. So,
well, the definition of an expert is that you are profound in whatever your profession is. You are a deputy. You just claim to be an expert. However, in your sworn affidavit, you said you don't know every Colorado statute. That pretty backwards, is it not?
Again, depends on your definition of an expert.
Not my definition. It's the standard definition of an expert. You just said you were an expert. In your sworn affidavit, you said you don't know every Colorado statute. That would go against being an expert, which again would probably lead into that you're training people who don't know that either. Correct?
No.
And that's your opinion? Or is that a fact?
I'm a little confused about the question. Opinion or fact to what?
Was it your opinion that you're not an expert and that you don't need to know every Colorado statute, even though you just said you're an expert?
Can you rephrase the question so that way I can better understand it?
Well, you said you were an expert. You sworn that you don't know every Colorado revised statute.
Mm-hmm.
You are training people in the ways that you feel are correct. However, you just admitted you don't know every Colorado statute, but you also admitted that you're an expert.
Mm-hmm.
Would that not be indecisive? In the fact that you're not an expert, you don't know Colorado law.
Again, I'll take you back to the definition of an expert. So if your definition of an expert is somebody who knows every single law in CRS, then no, I am not an expert. But per the courts, I've been sworn in as an expert on traffic.
What evidence have you been provided with that from a third party testimony that I'm a domestic terrorist? Have you been provided any evidence of that?
Domestic terrorist? I never used that word.
Citizen. Do you know what sovereign citizen means?
I know the general colloquial term.
Do you know what's an oxymoron?
And seriously, put the strongest possible emphasis on the moron part, because at this point, it's not even debatable. That's where we're ending things today. But I want to hear from you. How many sovereign citizen arguments did you catch throughout the video? Drop your count below and let's see who was really paying attention. And don't worry, this story isn't finished yet.
I don't understand your question.
Do you know what an oxymoron is?
No.
Okay, I'll break it down as simple as I can for you. 2 words that mean 2 different things. Sovereign means you're independent. Citizen means you are governed by somebody. You cannot use those words together. They are legally irrelevant. Okay? It's also defamation. And that's under Colorado law. Did you know that?
No.
So have you been provided any evidence that I am a sovereign citizen or a domestic terrorist?
Officer Jen Cruzy, who pulled you over for Blue River, advised me that you had provided her with what she called a sovereign citizen ID. I was not there for that. That is what she told me. That's officer to officer communication and information. That is the only information that I have, the only background that I have on you. I don't know you outside of that.
And so it's her word that a state issued, Department of State issued passport is what she considers a sovereign citizen document.
That is not how she described it, so you'd have to ask her.
That's what you just said. You just said that she was presented a sovereign citizen, what she considered a sovereign citizen ID. So doesn't that go against what you just said?
No, that's what she told me.
And what proof does she have?
You'd have to ask her.
So again, this is third-party hearsay testimony with no factual evidence, correct?
No, this is what Officer Cruzy told me, so you'd have to ask
That's
her.
hearsay. Do you know what hearsay is?
It's officer to officer communication and information.
That doesn't matter.
It's in good faith. It does matter.
Objection, Your Honor. Clearly, it's the fellow officer rule, and it's not hearsay for the purposes of this motion's hearing.
Repeating a statement made by someone who isn't present to testify is generally considered hearsay. However, there's a recognized exception for communication between officers acting in the course of their duties. So, in this situation, that argument doesn't hold up.
That's your dash cam, correct?
I believe so.
Okay. So again, for the record, do you want me to leave this with her?
Let me make sure I'm looking at the same. You're welcome to leave it up there for
Do you
now.
need it?
I don't think so.
So for the record, I just presented, I believe it was Exhibit A. Forgive me.
It was.
Okay, thank you. Dash cam photo of Deputy Courier's, of my truck from Deputy Courier's cruiser on, I believe it's 614. Did you make any attempt to clear my license plate?
I did. I went behind and I wiped some of the dust off, but I was still unable to see underneath it.
Okay, and so you just testified that it was a smoke-covered license plate. And now you just said that you attempted to wipe dust or mud off of it, correct?
Yes.
Okay, now in that photo, there's, given the very poor, in my opinion, quality for 2025 when phones have 8K capabilities, why your dash cam doesn't have that type of capability is unbeknownst to me. But clearly, that truck is covered in mud. Are you familiar with the term mud season in this county?
Yeah.
Your Honor, I would object to this line of questioning as it's irrelevant. The applicable statute 42.3.202.2b just says that a person shall not operate a motor vehicle with an affixed device or substance that causes all or a portion of the license plate to be unreadable by a system used to automatically identify a motor vehicle. Such a device includes, without limitation, a cover that distorts angular visibility, alters the color of the plate, or is smoked, tinted, scratched, or dirty so as to impair the legibility of the license plate. Whether it's mud, dirt, or dust, it all qualifies under the same statute, so I don't believe that this line of questioning is relevant at all.
In that same statute, it does clarify that mud during specific times of the year, just like winter when your car is covered in snow, it just advises that at the quickest time to clear it when possible.
Well, Mr. Martinez, you're right. That is the statute that's applicable here. I do think that this questioning is still relevant. So I'm going to allow Mr. Chavez to explore this a little bit more. But once the point's been made, I'll ask him to move on. So that objection's overruled. Go ahead, Mr. Chavez.
Thank you. Other than what you testified as my demeanor,
Oh, thanks.
in any other way did I obstruct you physically from doing your job?
Physically? No.
Okay. Are you aware that under Colorado Revised Statute 188104 and Colorado law requires physical interference, and that even in your own affidavit, you clearly said none of that existed?
By not providing me with driver's license registration or insurance, that is interference.
Under Colorado law, it's not, because you never articulated a crime. You never articulated probable cause.
Is there a question?
Make sure that's a question.
Did you ever identify probable cause?
Yes. And it was signed off on by the DA and the judge.
And what crime did I commit?
Obstruction and not providing me with a valid driver's license, not providing me with insurance, expired registration, and obstructed license plates.
And is the body cam footage here to prove that you ever asked me those questions?
I have it on my computer. I'm not sure if Mr. Martinez has it. I could also definitely pull it up on my computer if need be.
I moved to strike that.
Overruled. I don't need to strike it. I understand that you're objecting to that answer.
Did you take an oath when you became a deputy?
Yes.
What does that oath entail?
That was 4.5 years ago. It's not consistent across all departments, so it's not something that's set. So honestly, I do not remember the exact verbiage or anything of that, but I know it does include
that verbiage. But
Mhm.
I asked for what is your oath? What do you oath to? What are you sworn to uphold?
It does include upholding the Constitution.
Okay, and are you aware that under the Constitution, any laws repugnant of the Constitution are null and void?
Am I aware that laws that are contradictory to the Constitution?
Repugnant is the word that I used. Do you know what repugnant means?
I do not.
Repugnant means that it's notwithstanding. It means that it's not enforceable. It means that it's null. It means that it's void. Unenforceable.
Sure, sometimes states.
No, it's not sometimes. Do you know what the Supremacy Clause is?
The Constitution overrules state laws.
Do you know what article and section that's in?
No.
Your Honor, again, I would object to relevance. If he's challenging the validity of the law, that's a different venue than here. Obviously, there are other constitutional considerations than just whether or not a right exists. Such things
No,
as
they don't
for
exist.
me,
They're
intermediate
guaranteed.
and
Mr.
Mr.
Martinez.
basis review on the validity of laws that do potentially infringe on any constitutional rights.
I would agree that the question with respect to Deputy Turrier's testimony, so I will sustain that objection and ask Mr. Chavez to move on. It's certainly something that I can argue in his own arguments, but it's not relevant with respect to Deputy Courier. Okay, any more questions for Deputy Courier, Mr. Chavez?
Yes. Are you aware that using the defamatory label of sovereign citizen without evidence, it is a Brady Giglio violation requiring impeachment, disclosure, and suppression?
Objection, Your Honor. This has been asked and answered. The court has addressed this issue, and that if a jury was present, then it would be prejudicial, and that's what the aim of that law is supposed to represent, not for the purposes of this motion's hearing today. Further, I would note that she is not the one claiming he's a sovereign citizen. She was only citing a statement from another officer.
She put it in a sworn affidavit that was used for a false arrest warrant.
And again, Your Honor, quite frankly, the fact that he is or is not a sovereign citizen is not relevant to whether or not there was reasonable suspicion or probable cause for the criminal offenses that occurred on June 14th of 2025.
Mr. Chavez, what was the question again?
I asked her if she was aware that using a defamatory label in a sworn affidavit without evidence is a Brady Giglio violation requiring impeachment.
Okay. Do you think it's asking Deputy Curry to make a legal conclusion on that issue? I don't think this question has been asked, but I think the only question that would be relevant with respect to the mention of the term sovereign citizen would be whether or not she relied upon the use of that term in determining whether there was probable cause for the arrest in these circumstances. And that's about all that's relevant.
How long did you detain me on 6/14?
Rough estimate again, I believe approximately 30 minutes.
And you're aware that that's well above the standard time limit of about 15 minutes without probable cause or reasonable articulable suspicion?
There is no standard time limit. It depends on the facts and circumstances of the stop.
That directly contradicts a Terry stop.
Nope.
It does.
No, that's not correct. A Terry stop isn't measured by a stopwatch. It's judged by reasonableness. While the Supreme Court of the United States held in Rodriguez versus United States that officers cannot prolong a stop beyond what's necessary, that limitation doesn't apply when the delay is caused by your own actions, such as refusing to provide identification or interfering with the investigation. Officers are permitted to take the time reasonably required to complete the purpose of the stop, and any delay resulting from non-compliance is considered legally justified and attributable to you.
Are you aware that the courts operate under full disclosure and fiduciary duty?
That is not my realm of expertise. I wouldn't know about that.
Okay. Are you aware of what's commonly referred to as the CRIS system or the Court Registry Investment System?
No, and again, that's not my realm.
Are you aware of the term bond fraud?
No.
You don't know what fraud is or what a bond is?
Fraud, I don't know about bond fraud. That's, again, not something that I've dealt with or my area.
Was there any injured party or property damage during this case? Or during the stop, excuse me?
No property damage. As far as injured party, I mean, it's the people, Colorado. You need to follow the laws.
That the people is a fiction. It can't be an injured party. You aware of that?
No.
No, you're not aware of that, or
no?
Are you aware of the Sixth Amendment right to confront the injured party?
No.
Okay, so are you aware that under the Sixth Amendment, every living man or woman has the right to confront that injured party, and that injured party must be a living man or woman?
That would fall again under the realm of the courts. That's not something that law enforcement,
that's a Sixth Amendment right.
Something that me as a street cop would typically deal with.
Well, you're a deputy.
Mm-hmm.
Deputies are sworn to uphold the Constitution. Sixth Amendment is part of the Constitution. Is that correct?
Yes.
All right, Ms. Courier, going back to Exhibit A, which was admitted by the defense, can you see any numbers on that license plate on the back?
No.
Objection. It was established that the quality is pretty poor and it's covered in mud. She even admitted she tried to dust it off, and it's not a smoke plate cover.
The record run out that you object to her answer, but there's I don't hear an actual objection to the question, and I think the question's proper, so overruled.
Would you say your view of that license plate was obstructed?
My view of the license plate, yes. I did wipe the dust off and was able to see the plastic without the dust in the area that I was able to wipe off, and I still was not able to see a plate underneath.
Despite wiping it,
yes.
You still could not see anything?
Yes.
Okay. Was Mr. Chavez being referred to as a sovereign citizen any sort of factor in your determination of probable cause or reasonable suspicion?
No.
That was established independent of that fact?
Yes.
And you couldn't see that license plate the moment you saw him pass you on Highway 9, correct?
Correct.
And once again, is that individual that you pulled over Ryan Chavez here in the courtroom today?
Yes.
No further questions, John.
I do have one more question, if I may.
Yes, Mr. Chavez.
Are you aware, how long have you lived in Summit County?
Since I started working here, so
Okay.
about March of 21.
So you're aware of the term mud season, correct? Okay. What does that mean?
Depends on after the ski slopes close. I don't remember when the ski slopes close this year, and it's kind of determining on the people and whoever it is on when that actually ends. So it's a very vague term. But typically, again, when the slopes close to when summertime starts to pick up.
Okay, and you would agree that in the county, it's considered 2 mud seasons?
2 mud seasons.
Yeah.
One, that's a local thing where there's 2, then I'm not aware of it.
Do you not consider yourself a local?
No, I've only been here for 4 years, so I would think most locals would not consider me a local either.
Okay, so you're not aware that there is 2 mud seasons, in fact?
No.
I guess without being too specific, do you live on a rural road or a paved road?
Rural.
Okay, and you're aware that during mud season specifically, puddles form, mud forms, dust accumulates specifically on rural dirt roads,
Yes.
and it's uncontrollable?
For it to accumulate, yes.
But what was within your control was taking a moment to clean off your license plate before driving your so-called land canoe, especially considering you've appointed yourself today's expert on muddy conditions. And with that, we've reached the end of his unsuccessful cross-examination. Now it's time to move on to the motions he filed and see how those play out.
So, Mr. Chavez, at this time, you're welcome to provide your own testimony if you feel it's necessary. Otherwise, typically in a motions hearing like this, this would be the time that we allow argument from either side. So you can certainly state your position with respect to the motions that you filed. At this time, do you wish to provide any testimony under oath?
Yeah, I can.
Okay. So that would be limited to essentially your testimony related to the stop itself. Okay. And then we'll allow for some argument. Okay. So before you testify, could you please raise your right hand? Do you swear or affirm under penalty of law that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
All right, thank you.
For the record, my name is Ryan Chavez. I'm here under special appearance. I do not waive any rights. Again, my presence is under duress, coercion, and threat of arrest if I fail to appear. This is not a voluntary submission to jurisdiction. I reserve all rights and make no waivers. And it is well established in law that federal law and supremacy clause supersede any of the state statutes and laws that conflict with it. During the stop on June 14th, 2025, I was not speeding, which clearly she said I wasn't doing. I was obeying the traffic laws. I live on a extremely dusty and dirty road. My plate cover is not smoke tinted. It is clear. My truck is black. My plate is black. And I truly didn't know that it was that caked in mud when she pulled me over. I knew my truck was dirty, but I did not have any realization that it was that dirty in the back. And again, this is during mud season. I get up at 5:30 in the morning. I don't walk around my truck to check stuff. I just get up and go to work. When I was approached by Deputy Courier, I specifically asked her what was the emergency. She specifically said, your truck is too muddy. I can't see your plate. I just responded and said, well, I live on a dirt road. It's mud season. She then accused me of not having a front plate. She walked in front of my truck, looking right at the front plate. I had to estimate maybe between 5 to 10 feet in front of my truck, and completely lied, said I didn't have a front plate. I have a front and back plate. I believe I asked her if I was traveling, if I was traveling in any type of commercial capacity or working in commerce. Did I have for example, did I have an Uber light or a Lyft light? She just proceeded to escalate. I asked for a supervisor. I was denied that outright. And instead of calling a supervisor, she called backup, which proceeded to be 2 more Summit County sheriffs and 4 police officers, 2 from Breck, 2 from Frisco, which both of those are out of their jurisdiction, have no standing being there, and them as deputies supersede any local law enforcement. Clearly it was a sign of intimidation.
It's almost ironic. Basic double-digit arithmetic is being treated like some kind of high-level challenge, when in reality, it's as straightforward as it gets. Moments like that really highlight the disconnect between confidence and actual understanding, and it adds another layer to just how absurd this whole situation becomes as it unfolds.
I felt completely unsafe. These people are armed, and by her own admittance, she doesn't know the laws or all the laws. This went on for 45 minutes. At no point did I threaten her. I never threatened her with violence. I never yelled at her. I never obstructed her. And again, according to the law, under Colorado law, obstruction is a physical interference of her duty. And just because I refused to identify myself without probable cause or reasonable suspicion, articulate suspicion, which she could not provide me with, I'm not required to help her with her investigation or identify myself. I had broken no laws. A dirty plate is not, a dirty plate or a dirty plate truck is not a purposeful act to conceal anything. I didn't obstruct her in any way. I sat in my car, asked for a supervisor. I was denied. Again, this went on for 45 minutes. She completely failed to articulate any type of probable cause, reasonable suspicion. And she said she attempted to wipe off my plate, which I didn't see if she did that or not. But I do have front, rear, and inside cameras in my truck. I wasn't operating in a commercial capacity. I have a right to travel, a constitutional right to travel on a private road from point A to point B. Cannot be infringed upon.
You also have the constitutional right to remain in custody while holding on to the mistaken belief that the UCC or commercial licensing laws apply to operating a personal vehicle within the United States, which they do not. However, since he has chosen to testify on his own behalf, the prosecution now has the opportunity to carefully challenge and dismantle those arguments. As you watch, notice how uncooperative he is during questioning, and consider how that same behavior likely played out during the initial traffic stop.
Ms. Martinez, do you have any questions?
Yes. Would you like me to just ask it like that?
I think you can.
Okay.
That's fine.
So in your testimony just now, you admitted that your license plate was caked with mud, correct?
My whole truck is what I said.
Okay. And would that include your license plate?
Well, I mean, if it's my whole truck, then yeah,
So it would include your license plate.
that would be my whole truck.
So the answer is yes.
Yeah.
Okay. And that same statute that you keep citing, you realize that the word dirty is also used as part of that violation for obstructed license plate, correct?
Well, as I said before, it's very specific about the word dirty or mud covered or obstructed, and that includes snow.
And you just used the word or, correct? So that means it could be either one.
Well, do we get snow in August?
But what I'm saying is it could be either one, correct? By using the word or.
Well, it could be.
The answer, yes or no?
No, because what you're doing is
So
you're
it's
using
not-
legalese
so
to
or-
try to trick me.
So or does not mean one.
What are we
different.
speaking? Are we speaking English? Or are we speaking?
We're speaking
legalese?
English.
Okay,
So does or mean both? Or does it not?
clarify.
When it says dirty or smoked, does that mean that it could be both? Yes or no?
No, because if my plate cover is clear, which it is,
Why did you not provide your insurance?
well, she ran my plate. All that stuff comes up.
So you never gave her your insurance.
She didn't ask me to.
She did ask you to.
That's what she said she did. But you haven't proven that. Where's the body cam footage? Because I don't remember her telling me that.
Okay, but you never provided her with your insurance.
I don't need to. I don't need to provide
Is it a yes or no
identification. I don't need to
Is it a
provide
yes or no
insurance
question?
until she can articulate reasonable suspicion.
Yes or no, did you provide her insurance?
I don't need to.
So you did not.
I don't need to.
So you did not.
I do not need to.
Did you ever get out of your car during this
No.
interaction?
No. I just testified to that.
Okay, so how do you know that she didn't try to wipe the backside of your car?
Well, if you were listening, I said that's what she said, but I don't know if she actually did that. But she testified to it, just like she swore an affidavit, which is under the penalty of perjury, just like when she got up there. So if she didn't do it, then she lied, just like she did in her sworn affidavit.
Why was your registration expired?
I don't travel in commerce.
Were you driving on a road that day in Colorado that's paid for by the state of Colorado?
I travel in private. It's a right to travel. That's also protected under the Constitution, which you should know.
Yes or no, were you traveling on a road paid for by the state of Colorado?
What was that?
Were you traveling on a highway in the state of Colorado that's
What's
paid for
the
by
word
state?
that you just used?
Were you traveling on a road
Traveling.
in Colorado?
Traveling. Correct?
Objection, Your Honor, non-responsive.
I was going to respond. I asked him to clarify. He didn't.
Okay. I will ask you to answer the question, Mr. Martinez. Could you restate the question?
Were you driving on a road in Colorado?
I was traveling.
Honestly, I wish the prosecutor had asked whether he was traveling on foot in his Nikes or operating a gas-powered vehicle, but in the end, it wouldn't have changed anything. By dodging the question, he effectively answered it anyway. And with that, we move into his closing arguments, where he makes his final attempt to defend his position.
Statutes cannot override the Constitution. Article 6, Clause 2 of the Supremacy Clause makes clear any statute repugnant to the Constitution is void. Jurisdiction requires lawful cause, injured party, and sworn testimony. And very few of those are present. There's no injured party. There's no property damage. Under CRS 18.8.104, a person commits obstruction only if they knowingly obstruct, impair, hinder the enforcement of the penal law or the preservation of the peace by a peace officer acting on the color of his official authority. In Dempsey versus the People, Colorado, Supreme Court held that verbal challenges, passive resistance, or refusal to provide identification without a predicated crime do not satisfy the statute. At no point did I hinder her from doing her job. Never left my vehicle, never physically stopped her from doing her job. She was clearly able to identify me from my plates without any type of reasonable articulable suspicion or probable cause. She did threaten me. And this court has still yet to provide a living man or woman of the injured party. The state or the people cannot be the injured party. This is a guarantee by the Sixth Amendment right. Further, Terry versus Ohio and Delaware versus Prouse, the Supreme Court ruled that stops must be based on articulable suspicion or criminal activity. Criminal activity. A dirty plate or hard to see plates absent any criminal conduct doesn't meet this standard. Lindstrom versus Romeo. The 10th Circuit confirmed that verbal criticism or passive conduct is not obstruction. The conduct here was a lawful assertion of my rights. Colorado's own law requires that obstruction involve an act of physical interference with law enforcement duties, as held in Colorado's own appeals court, People versus Brandon, 2001. Verbal challenges do not constitute obstruction unless the conduct actually prevents an officer from performing her lawful duty. Here, she was able to identify me. She saw my front plate. She identified me, and all of that insurance, registration, all of that comes up. When it comes to registration, I do not travel in a commercial capacity. Colorado's own DMV guidelines state that a driver or driving on roadways and state are specifically for commercial uses, people that are being paid to transport somebody or transport goods and services. I don't do either of those. I travel the roads privately. It is my right under the Constitution to travel on the roads privately from point A to point B. Courier's own affidavit is absolutely defamatory. It's absolutely perjury. There is no evidence, no proof that I have ever claimed to be a sovereign citizen. Under the Department of Justice and the FBI, to call somebody a sovereign citizen, you have labeled them a domestic terrorist. And Colorado's own law condemns that usage, especially in a court like this one right here. It is biased. It's absolutely prejudicial. There is no evidence of it. I am well aware of my constitutional rights and guarantees. I assert them properly. I do not live my life and travel on the roads in an illegal manner. I respect the Constitution of this state, which is bound to the Constitution of the United States and the Supremacy Clause. Federal law and Supreme Court rulings supersede this. I am well aware of the bonds that are created for each court case and that are inherently a direct conflict of interest. This is proven by the court registry investment system. It constitutes double recovery and bond fraud under 18 USC 872. I respectfully demand full disclosure, QSIP numbers, registration records, gap accounting, receivable and payables, proof of settlement and payments. I reserve all of my rights to exercise them. And if I need to place this in the hands of the federal United States District Court, pull both of your bonds and sue you both in your both private and public capacity, I will do that. So let the record show I have reserved my rights to do that. I have full intentions to do that. This case is completely predicated on a false perjury affidavit. At no point did I obstruct Courier from doing her job, never physically stopped her from doing her job. She identified me. She never articulated reasonable suspicion of a crime, never articulated probable cause. I wasn't speeding, wasn't breaking any laws. I travel in private. I do not travel in commerce.
I told you he was going to pull out every argument straight from the sovereign citizen playbook, and sure enough, he didn't hold back. But now we've reached the moment where it really counts. The judge steps in to deliver the ruling and methodically shuts down each and every one of those claims.
Okay, well, I am prepared to rule on a few of the issues, and I may reserve my ruling for a written ruling on a few of the issues that we addressed today. First, with respect to jurisdiction.
Excuse me.
Of course. So jurisdiction, in order for a criminal or traffic case to be prosecuted and judgment to be legally imposed, the trial court must have jurisdiction of the subject matter, essentially jurisdiction over the offense and jurisdiction over the person of the accused. And with respect to the subject matter jurisdiction, CRS 18-1-201 provides that a person is subject to prosecution in the state for an offense which he commits by his own conduct or that of another for which he is legally accountable if the conduct constitutes an offense and is committed either wholly or partly within the state. And the allegations in this case are that Mr. Chavez's actions occurred in Summit County, Colorado. Therefore, by statute, and I understand that Mr. Chavez challenges the Colorado revised statutes or the applicability of those statutes, but they are applicable to this case, and they do confer subject matter jurisdiction under these proceedings. So I do find that this court has subject matter jurisdiction over the charges alleged in this case, which are obstructing a peace officer, the obstructed smoke device, operating a vehicle with an expired license plate, and no proof of insurance upon request. And with respect to personal jurisdiction, the physical presence of the defendant in court confers jurisdiction over the person, and the courts may acquire jurisdiction over the person of a criminal defendant in a number of ways. Usually, jurisdiction over the person is acquired when a person is arrested or otherwise taken into custody by law enforcement authorities and charged with an offense. Jurisdiction over the defendant is also acquired through the defendant's appearance in court, whether voluntary in response to a summons or otherwise. So I understand that Mr. Chavez objects to the voluntariness of his appearance in court, but that is actually irrelevant with respect to personal jurisdiction. I do find that this court has personal jurisdiction over Mr. Chavez with respect to these proceedings. And regarding the reasonable suspicion for the stop, Deputy Courier did testify that on June 14, 2025, she was on patrol on Highway 9 near mile marker 92 and observed a vehicle that ultimately was determined to be Mr. Chavez's, in which the license plate was obstructed. And upon contact with that vehicle, and upon determining the license plate number, was able to determine that the registration was not valid, and inquired with Mr. Chavez regarding proof of insurance. The court does find that Deputy Courier has provided a reasonable articulable suspicion that a traffic offense had been committed that did justify an investigatory stop. Now, I don't think the inquiry ends there. The investigatory stop does need to be reasonable for the purposes of the stop. And I understand that the stop lasted approximately 45 minutes or so, I think, based on Mr. Chavez's testimony. But the initial stop was because the license plate was obstructed in some way, and Deputy Courier was justified in performing an investigatory stop to inquire further regarding the license plate. And she was justified in requesting identifying information from Mr. Chavez. The statute 42-3-202 in subsection 2B does state that a person shall not operate a motor vehicle with an affixed device or a substance that causes all or a portion of a license plate to be unreadable by a system used to automatically identify a motor vehicle. Such a device includes without limitation a cover that distorts angular visibility, alters the color of the plate, or is smoked, tinted, scratched, or dirty so as to impair the legibility of the license plate. So I would note that I understand Mr. Chavez's testimony that it was mud season, that his car was dirty. I think it is clear from the exhibit that he introduced as Exhibit A that his and that there was dirt covering the license plate. There was conflicting evidence or testimony with respect to whether or not Deputy Courier was able to clean off all the dirt and see through the license plate. It's unclear to me whether, how many layers of dirt might have been on there. Obviously, during mud season, especially if Mr. Chavez lives on a dirt road, there could be several layers of dirt. It might take some time to actually get all that dirt off of there. But with respect to the reasonable suspicion, Deputy Courier had reasonable suspicion to perform an investigatory stop. And I do think Exhibit A actually confirms that her stop was justified. And ultimately, she was justified in requesting information from Mr. Chavez. He did not provide proof of insurance upon request based on Deputy Courier's testimony, and she was able to determine that the license plates were expired. So I do think that there's reasonable suspicion and probable cause that has been established with respect to the 3 traffic infractions. So meaning 42-3-202 and 42-3-114 and 42-4-1409. The question is whether the remaining question for me, and I think I'm going to take this issue under advisement and issue a written order, is whether or not Mr. Chavez obstructed by failing to provide that information. And clearly, if he failed to provide the proof of insurance, he can be charged with failing to provide proof of insurance. The question that remains for the court is whether or not it's truly obstruction under 18-8-104 to not provide additional information once the officer has determined the identity of the driver and the license plate number for the vehicle. And that's something that I need to review some case law. I do understand Mr. Chavez cited Dempsey v. People, and that's in 117 P. 3rd 800.
Excuse me, sorry.
And that case states the obstruction statute contains the essential elements that the defendant knowingly obstructed the enforcement of the penal law by an officer acting under color of official authority. Term enforcement in the statute includes those activities which a peace officer is under a duty to perform in order to give effect to the penal law. An officer is authorized to stop any person who he reasonably suspects has committed or is about to commit a crime, to give his name and address, identification if available, and an explanation of his actions. We have held that to justify such a limited intrusion, a police officer must have an articulable and specific basis in fact for suspecting that criminal activity has occurred or is about to take place. Thus, the officer's command must be attached to performance of an official function, such as an investigatory stop that is justified by articulable basis and fact. In that case, the evidence at trial proved that Dempsey refused to cooperate with the officer in several ways. Dempsey refused to provide his identification for the officers to write him a summons. Dempsey stated repeatedly instead that he needed to speak with his lawyer. And 3, Dempsey walked away, placing his hands in his pockets. And 4, he struggled with the officers after they had grabbed his arms for their own safety, still refusing to cooperate with their attempts to issue him a summons. That case isn't directly on point. The facts alleged here are somewhat different, and that's why I think I need to engage a little bit further on whether when Mr. Chavez was essentially seated in his car and refused to provide that information, whether or not that actually rises to the level of obstruction under that specific statute. So again, I'm going to have to take that issue under advisement. What I'm going to do, Mr. Chavez, is set this case for a status hearing or status conference about 4 weeks out. I will issue my order as soon as I can get it to you. And then we'll determine how to proceed. If you, at that time, after I've made my ruling on that issue, you'll obviously be free to enter a not guilty plea at that time. We can schedule the case for trial if necessary, or we can proceed as you wish. So I'm going to set a status conference so I can get that ruling out.
May I make a request, John?
Yes, sir.
Could I appear virtually? I'm going to be traveling in the next several months.
Yeah, and I think we've discussed that previously. I'm okay with the virtual appearance.
I appreciate that.
That date work for you, Mr. Chavez?
I'm going to be obviously completely honest here. I am starting a new job. It does require a lot of travel, as I just said.
And that wraps up the video. If you were paying close attention, I'm genuinely curious, how many sovereign citizen arguments did you catch along the way? Drop your count in the comments. I'd love to see who really nailed it. And trust me, this isn't over yet. When this case finally makes its way to a jury trial, you already know I'll be breaking it all down right here with you. So if you enjoyed the video, learned something new, or just like this kind of content, make sure to stick around. There's a lot more coming your way.